from the defendant ex parte next door in courtroom 3C here momentarily. I do understand that the state opposes this request, but nonetheless, I am going to make a record of what it is that they're asking for in the ex parte request and see if it can be fleshed out any better. So I will do that. As soon as that is concluded, we'll have our charge conference. Thank you. All right, if standby counsel would make their way next door to courtroom 3C. As soon as our court reporter relocates, we'll begin. Thank you.
Do we need to remain in the courtroom?
Yes, I'll come right back here.
Okay. Yes.
You can be at ease. This will take 10 minutes, 15 minutes maybe. Returning to 18B 1541-1. This is the state of Georgia versus Tiffany. Nicole Moss, the defendant's present, along with standby counsel. State's counsel's present as well. First, with respect to the ex parte proceeding that I've just conducted, I've taken no action with respect to the matter addressed in that proceeding. We will go ahead and have our charge conference. Ms. Fitzpatrick will be handing out a draft version of the charge. You will recall that the state submitted 22 requests to charge. The defense submitted none. I'll give you a few minutes to look at the proposed draft version of it, and then there's several corrections that I would like to suggest, and then some other discussion before we finalize the charge. As you look through it, you'll find it's somewhat over-inclusive. There'll be things getting removed. Let me know when you're ready.
State's ready, Your Honor.
Ms. Moss, are you ready? Very good. I'm going to go through the draft version of the charge, review with you those things that I think should be changed, perhaps ask for your input. But if I suggest a change and I don't hear some disagreement, I'll assume there is general agreement with the suggested change. The first area of proposed improvement would appear on page 3. Second paragraph, it makes reference to attorneys. Since we do have one pro se litigant, I'm going to change that to parties. So to read the remarks of the parties or questions asked by the parties. You'll note that that second paragraph right after that is in bold. That's only to distinguish the fact that that was one of Ms. Jones's requests. The final version that will be presented to the jury won't be bolded, so it won't be distinguishable in any way whatsoever from the rest of the document. The next area of change that I would suggest begins on page 7, about 1/3 of the way down, beginning with the paragraph that says sometimes evidence is admitted conditionally. That and several pages thereafter all have to do with statements that the defendant made while in custody. None of that evidence was presented. So the balance of that page, from the word sometimes all the way down, would be eliminated, as would all of page 8, all of page 9, all of page 10, all dealing with a topic that was, or evidence that was not submitted to the jury. Beginning on page 11, there are some other things that we need to discuss. This is the instruction on the 404B evidence. That second full paragraph beginning with the word sometimes evidence is admitted needs to be adjusted as follows. I would propose that it would read sometimes evidence is admitted for a limited purpose, period. Such evidence may be considered by the jury for the sole issue or purpose for which the evidence is limited and not for any other purpose. In order to prove its case, I think we should eliminate the reference to counts 1 through 5 because it's really applicable to the entirety of the case. In order to prove its case, the state must show intent and must negate or disprove accident or mistake and may show motive. That would all remain the same. In that second to last paragraph, beginning with the words "to do so," there's a parenthetical, "unless otherwise instructed," that I would eliminate from that. If I'm going too fast, let me know. The next change that I would suggest would appear on page 13. There's a charge about prior convictions, and I think that was submitted as State's Exhibit number 1. It deals with the conviction of the co-defendant. Unfortunately, the way that actually reads, it says that the conviction shouldn't be considered for any other purpose. Well, of course, I just got done explaining to them what the purpose is they could use her prior conviction for. So I would propose amending it to read as follows. You have received in evidence a prior conviction of a witness. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. The next proposed change would be on page 14. That is the charge on parties to the crime. There are 4 ways that you can be a party to the crime. Only the first 3 seem applicable under the facts of this case, so I would eliminate the 4th or D option. So it would read A, B, or C, and then eliminate the reference to D. On page 16, at the bottom, you'll see a paragraph that's in italics. That was State's request number 5. Looking at the pattern charges, that is a pattern charge, but it's only to be given to the jury if they have questions or ask for additional clarification on the issue of premeditation, so I'll not be giving that paragraph. So the last paragraph on 16 would be eliminated. Page 19, you may recall discussions in the past where the defense had, when she was being represented, made reference to a request to have murder in the second degree considered. I don't see that there's any evidence to support a charge on murder in the second degree. I'd be happy to hear from you if you think otherwise, but murder to the second degree is predicated on a finding of some negligence or cruelty to children in the second degree, which is negligence standard. So I don't believe the evidence supports the giving of a murder in the second degree charge, so I would eliminate that on page 19. Above that, there are 2 little parentheses that would be eliminated, just stylistic changes. Also, 2 little parentheses that appear on the last paragraph of page 19. Doesn't affect the meaning, it's just cleaning up it typographically.
Taking the language in parentheses out, is that what you said, Your Honor?
No, I'm just
The parentheses.
the parentheses.
Oh, I'm
The
sorry.
language is going to remain, just the parentheses themselves would be removed.
Your Honor, in that case, grammatically, in the last paragraph, it should say that for the purpose of this code section, malice means an actual intent to cause the particular harm produced. Okay, I'm sorry. That is physical and mental pain, comma, without justification or excuse.
Yes, I think it reads okay the way that it is. But yeah, by all means, keep an eye out for that. Page 20. In the middle, there's a definition of cruelty to children in the second degree. As I've said, I don't believe that's supported by the evidence. There's no evidence to support a negligence-based charge, so that'll be eliminated. Ms. Jones submitted 2 alternative versions of how to define cruelty, or concealing the death of another. It's immaterial to me which one we choose, but we don't need to choose it or charge it twice. So does the state have a preference? Page 20. It is, yes. The last 2 full paragraphs on page 20.
Your Honor, the first one mirrors the language of the indictment. The first paragraph where it says, a person who by concealing the death of another hinders the discovery. Whether or not such person was, I believe that's the indictment language, the first one. In any event, the state would agree to just mirroring the indictment language.
Yeah, The indictment is worded as follows: whether such person was lawfully killed. The code section says unlawfully killed. I'm not sure there's a material difference in the two. We'll check the code section. It'll follow whatever the way the code section actually reads. But we'll use the first of the two alternatives, eliminating the second. If you look on page 22, there was a provision made for finding of a lesser included offense of murder in the second degree. As I pointed out, that's not an alternative that I intend to present to the jury. So, of course, that paragraph, the first full one on the top of page 22, would be eliminated. Those are all the suggested changes that I have. Any other changes or suggestions for improvement by the state?
No, Your Honor.
Any changes or suggestions for improvement by the defense?
No, Your Honor.
Mr. Porter, I've prepared a proposed verdict form. Would you take a look at it and approve it as to form, and please show it to Ms. Moss as well?
Your Honor, the verdict form is acceptable to the state.
Thank you. Ms. Moss, any objection to the form of the verdict? All right, thank you all very much. That'll be the verdict form that we use. That, I believe, concludes our charge conference. Unified Superior Court Rule 34, sometimes known as the Unified Appeal in Section 3A1, requires the court to conduct proceedings after the close of evidence. Following matters shall be concluded during the conference after the close of the evidence. A, written request to charge shall be presented to the court for ruling. As I've already outlined, all those requests to charge that were presented by the state have been considered. There were no such requests to charge presented by the defendant. B, the court shall make a final ruling on any issues as to which a tentative ruling or no ruling was made during the presentation of the evidence. Mr. Porter, are you aware of any rulings that I have not finalized?
Your Honor, I guess that sort of depends. I'm not aware of anything within the context of the trial or in the pretrial motions. There is a motion floating that what has been actually filed by standby counsel, but with the court's announcement, the state's ready to argue that motion at any time that the court deems fit. At this point, we believe that motion is premature prior to any verdict by the jury. But
we don't know whether or not it will become relevant until after we get a verdict.
that's the only motion that I'm aware of that is still pending, if that's the right word.
Let me articulate it a different way. Are there any matters ripe for consideration at the moment?
None that I'm aware of, Your Honor.
Okay, Ms. Moss.
No, Your Honor.
Very good. C, the court shall hear any timely and otherwise proper motions or objections the defense wishes to present. Defense counsel shall be given an opportunity to perfect the record by making a tender of proof as to any evidence that was excluded by the court. Ms. Moss, would you like to do that?
Yes, sir, Your Honor.
D, the court shall ascertain whether the parties have reviewed Part 3, I through Q of the checklist and are prepared to raise any of these issues in a timely manner. Has the state reviewed I through Q of the Unified Appeal checklist?
I'm familiar with it, Your Honor. I've reviewed it at previous meetings.
Numerous times, I'm sure. Ms. Moss, I gave you a copy of that back when we got started some time ago. Have you had the opportunity to review it?
Yes, I have, Your Honor.
And you've reviewed the sections that I described?
Yes, sir. I believe so.
Defense counsel, in this case the defendant, shall be advised that objections to the state's closing argument will be waived if not raised as soon as grounds for such objection arise, unless explicit permission is granted to reserve objection until the conclusion of argument. You understand that, Ms. Moss?
Yes, sir, Your Honor.
And finally, Section E, the court shall give the defendant an opportunity to state any objections he or she may have to defense counsel or to the manner in which defense counsel have conducted or are conducting the defense. Obviously, a somewhat unique situation here, ma'am, but anything that you want to raise in connection with that?
Yes, sir, Your Honor.
All right. Is there anything else we need to address on behalf of the state before we recess for the evening?
Nothing on behalf of the state.
Anything on behalf of the defendant? Thank you. I would anticipate that we'll begin with the closing arguments of counsel at 9 o'clock Monday morning. Thank you all very much. Have a pleasant weekend. We're in recess.
Well, you got to make the question is, have you reviewed the preparation?